Imagine this. You have spent years building your life inside the United States of America. You followed every rule. You paid every fee. You filed every single form on time. You waited, sometimes for years, sometimes for more than a decade, legally, patiently, honestly. And now, right at the finish line, your green card application gets flagged. Not because of a criminal record, not because of fraud, not because you broke a single law, but because of something you posted on social media. Something you said at a campus protest, something you believed about a war happening thousands of miles away in a place called Gaza. According to internal Department of Homeland Security training documents reviewed and reported by the New York Times this past weekend, this is not a hypothetical scenario. This is reportedly the new reality of the U.S. immigration system in 2026. And if you are currently on a work visa, a student visa, or anywhere in the green card process, what you are about to hear could be the most important immigration news you have seen all year. The story broke this past Saturday when the New York Times obtained and reviewed internal training materials distributed within U.S. Citizenship and Immigration Services, the federal agency that processes green card applications. These documents had never been publicly reported before. What those documents reportedly reveal is this. The Trump administration has instructed immigration officers to treat certain political expressions, including participation in pro-Palestinian protests and public criticism of Israel on social media, as what the official guidance specifically calls overwhelmingly negative factors when reviewing applications for permanent residency. These are not anonymous leaks. These are internal DHS training materials that the New York Times says it reviewed directly. Multiple major news organizations subsequently confirmed the reporting. And to be precise about what this means, this is not a publicly codified law passed by Congress. This is internal agency guidance, training materials telling officers how to exercise their discretion. But that distinction matters less than you might think, because immigration officers already have enormous discretionary power. When official guidance tells them to treat something as overwhelmingly negative, that guidance shapes real decisions on real applications filed by real people. According to these training documents, immigration officers have been instructed to reject applications from anyone with a history of, and these phrases come directly from the official guidance, endorsing, promoting, or supporting anti-American views, or anti-Semitic terrorism, ideologies, or groups. So far, that might sound like standard national security language, but here is where it becomes genuinely controversial. The training materials reportedly include criticism of Israel as a specific example of what qualifies as problematic speech. The documents cite as a concrete, illustrative example of conduct that could disqualify an applicant a social media post reading, "Stop Israeli Terror in Palestine," accompanied by an image of the Israeli flag crossed out. They also reference images depicting a map where the name Israel has been replaced with the word Palestine, listing this as an example of anti-Semitic content. Think about what that means practically. Hundreds of thousands of immigrants, students, engineers, doctors, researchers have shared posts like these on social media, often during periods of intense global grief over civilian casualties in Gaza. Some shared them in 2023. Some shared them earlier. Under the reported guidance, those posts are now potentially relevant to their green card applications. And it goes beyond social media. The training materials also reportedly instruct officers to pay specific attention to applicants who participated in pro-Palestinian campus demonstrations, particularly those that swept American universities following the October 7, 2023 Hamas attacks and the subsequent war in Gaza. According to the documents, officers have been told to focus particularly on aliens who engaged in on-campus anti-American and anti-Semitic activities. The word aliens here is the legal term for non-citizens, meaning every international student, every work visa holder, every green card applicant who attended those protests. The training materials also reportedly describe flag desecration, burning the American flag, as a negative factor. This is notable because the United States Supreme Court has ruled on multiple occasions that flag burning is a constitutionally protected form of political expression for American citizens. The inclusion of flag burning in immigration vetting guidance creates what legal experts describe as a sharp tension with established constitutional precedent. And there is a procedural dimension to this that makes the stakes even higher. According to the Times report, immigration cases that involve potential anti-American and/or anti-Semitic conduct or ideology must now be escalated, meaning they cannot simply be processed by the reviewing officer. They must be referred to the officer's manager and to the agency's general counsel's office. This creates a mandatory bureaucratic review process triggered by political expression. If your application is flagged under these guidelines, it doesn't move quietly through the system. It gets elevated. It gets scrutinized at a higher level. It gets reviewed by the agency's top lawyers. Now, to understand how significant this reportedly is, you need to understand the history of ideological vetting in U.S. immigration. Ideology has always played some role. For decades, U.S. law has barred green cards for members of communist or other totalitarian parties, people who have advocated anarchy, or those who have called for the violent overthrow of the U.S. government. Those restrictions are long-standing and have been upheld by courts. But what the Times reporting describes is a meaningful expansion of that tradition. The New York Times itself noted that the previous ideological bars focused on violent or anti-democratic movements, communism, anarchism, revolutionary violence. What is now reportedly being implemented extends ideological vetting to political commentary on a specific foreign military conflict, commentary that is widely shared, widely debated, and considered by many legal scholars to fall squarely within the traditions of protected political speech. The Times analysis also found that green card approvals have fallen by more than half in recent months. And the Wall Street Journal reported earlier this year that in 2025, for the first time since 1935, more people left the United States than entered it, a net outflow that was a historical first in the modern era. The administration has responded directly to this reporting. Zach Kaler, the official spokesman for U.S. Citizenship and Immigration Services, told the New York Times, "If you hate America, you have no business demanding to live in America." Abigail Jackson, a White House spokeswoman, said the restrictions have nothing to do with free speech and that they aim to protect American institutions, the safety of citizens, national security, and the freedoms of the United States. Joseph Edlow, the director of USCIS, told Congress in February, "There is no room in America for aliens who espouse anti-American ideologies or support terrorist organizations." The administration's position, clearly stated on the record, is that this is about national security, about ensuring that people who hold values fundamentally hostile to the United States and its allies are not granted permanent residency. Critics, including immigration attorneys, constitutional law scholars, and civil liberties organizations, argue the reported guidance goes far beyond that stated purpose. They say the practical effect of the training materials is to penalize political speech about a foreign policy issue, speech that millions of American citizens engage in freely and without consequence, simply because the applicant happens to be foreign-born and seeking permanent status. The real-world impact on immigrants currently in the system is significant and immediate. CNN reported that over 6,000 student visas had already been revoked since the beginning of 2025, with many of those revocations connected to pro-Palestinian activity. Secretary of State Marco Rubio has reportedly revoked visas of pro-Palestinian student activists, including one whose visa was canceled after she wrote a newspaper column criticizing her university's response to pro-Palestinian demonstrations. The Department of Homeland Security has also reportedly discussed the possibility of reviewing social media histories of tourists visiting the country, extending ideological scrutiny potentially even beyond the immigrant population. For green card applicants specifically, immigration lawyers are now raising urgent questions. USCIS has been checking social media accounts for years. This practice itself is not new. But the scope of what is now reportedly being flagged represents a fundamental shift in the nature of that scrutiny. Previously, social media checks were primarily focused on violent content, criminal associations, and verifying facts stated in applications. The reported training materials extend that scrutiny to political viewpoints, specifically viewpoints about the Israeli-Palestinian conflict. The response from the legal and advocacy community has been substantive. Immigration law organizations have described the reported guidance as a potential violation of due process principles, raising questions about whether applicants can meaningfully challenge a denial that rests partly on protected political expression. Civil liberties groups have emphasized the chilling effect, the concern that even immigrants who have posted nothing that would technically trigger this policy will now self-censor entirely on political matters, fearing any expression could be used against them. American Jewish groups are themselves divided on this reported policy. Some have expressed support, framing it as a necessary response to rising anti-Semitism on campuses. Others, including several prominent Jewish civil liberties organizations, have publicly criticized it, arguing that it conflates opposition to Israeli government policy with anti-Semitism in a way that is both legally problematic and potentially harmful to Jewish communities by generating resentment and limiting open debate. And here is the broader global dimension of this story that cannot be overstated. The United States has, for generations, attracted the world's most talented students, researchers, engineers, and professionals. A significant portion of them come from Muslim-majority countries: Pakistan, Bangladesh, Egypt, Turkey, Indonesia, Nigeria, countries where the Palestinian cause carries deep personal and cultural resonance. Many of these individuals have spent years in the American educational and professional system, contributed to American institutions, paid American taxes, and built their lives around the expectation of permanent residence. The message that the reported training materials send to those individuals is a complicated one. It says, your professional contributions are valued, but your political voice on a specific global conflict is not. It says the path to American citizenship runs through a new kind of ideological checkpoint that did not exist in this form before. Whether that message is a legitimate exercise of national sovereignty or a departure from the principles of open expression that define American identity, is a debate that is now actively unfolding in legal circles, in Congress, and in the public square. Let's be precise one final time about what the reported training materials specifically identify as potentially disqualifying. Social media posts deemed to express criticism of Israel, support for Palestinian political rights, or opposition to Israeli military operations. With the specific examples in the guidance including posts reading, "Stop Israeli Terror in Palestine," and images showing the Israeli flag crossed out. Participation in pro-Palestinian campus demonstrations, particularly those following October 7, 2023. Flag desecration, burning or otherwise desecrating the American flag, listed as a negative factor despite Supreme Court precedent protecting this as political expression for citizens. Content broadly categorized as anti-American or subversive, with officer discretion playing a significant role in interpretation. Association with or promotion of what the guidance categorizes as anti-Semitic rhetoric through rhetorical or physical actions. Any case triggering these factors reportedly must be escalated to senior officials and the agency's general counsel. It cannot simply be decided at the officer level. Where does this go from here? Legal challenges are being discussed and prepared. Multiple civil liberties organizations have signaled they are examining the reported policy, and immigration attorneys are already advising clients on how to respond. Congressional attention is also anticipated, with questions being raised about whether internal agency guidance can constitutionally penalize political speech in the immigration context, and whether the reported expansion of ideological vetting requires legislative authorization. For the individuals currently navigating the system, immigration attorneys across the country are now giving consistent advice. Conduct a full and honest audit of your social media history across every platform. Understand what you have posted, when you posted it, and how it might be interpreted under this reported guidance. Consult a licensed immigration attorney before your next application step. And document everything. What we are watching, according to this reporting, is a meaningful transformation in the questions that the American immigration system asks of its applicants. For most of American history, those questions centered on identity, legality, security in the traditional sense, and economic self-sufficiency. The reported guidance now adds a new category of inquiry: political alignment on a specific geopolitical conflict. The implications of that shift, for the millions of people in the immigration pipeline, for America's global reputation as an open society, and for the constitutional principles that define freedom of expression, are questions that courts, Congress, and the American public are now being forced to confront directly. The stakes could not be higher. And the story is still unfolding. If you are in the immigration process, or if someone you care about is, take this seriously, stay informed, and please consult a qualified immigration attorney. What you post, what you attend, and what you say publicly may now be part of how your application is evaluated. Share this with anyone who needs to know.